Hello and welcome to our July webinar on limitation of liability clauses, ins, outs, exclusions, and super caps, presented by Contract Nerds, a Docusign community. I'm Roma Khan, your host and the head of Contract Nerds. I'm also Senior Strategic Counsel at Docusign and the Contracts Queen. Before joining Contract Nerds, I was a tech entrepreneur, a general counsel, and a member and speaker of this wonderful community. I am honored to lead Contract Nerds and continue the excellent academic and social experiences of our beloved community. Contract Nerds is a blog, expert resource, and community dedicated to contracts and contracts professionals. Contract Nerds provides practical, relevant, and expert-driven content through our website, webinars, social media, events, and newsletter with over 25,000 subscribers. If you're not yet subscribed to our newsletter, please subscribe at the link in the chat so you can receive our weekly emails with tons of free content and training resources about contracts. I appreciate you for being here and for being a part of the Contract Nerds community, which is a very special community because people join us from all over the world to share their knowledge and stories. So, in the chat box, please share your name, where you're logging in from, and your LinkedIn profile if you'd like to make new connections. And I can see everybody sharing their info. Welcome, welcome. So today's webinar is on limitation of liability clauses. It's a very hot topic. We're going to talk about ins, outs, exclusions, and super caps with our amazing speakers, Brian Heller and Michael Epstein. It brings me great pleasure to introduce these accomplished experts joining us for today's webinar. Brian is a partner at Outside GC LLC and a technology and business lawyer with 20 plus years of experience. He's worked in large companies and small PE-backed startups representing vendors and customers. He's also the creator of Contract Law Tips and Checklists, a compilation of playbooks, cheat sheets, advice, checklists, and tips for reviewing a wide variety of agreements for a wide variety of tech transactions. Michael Epstein is a senior counsel at IBM, where he advises on complex technology, intellectual property, quantum, and artificial intelligence transactions. In addition to his role at IBM, Michael serves as adjunct professor at NSU Shepherd Broad College of Law, where he teaches drafting and negotiation of IP licenses. Sorry, it's negotiating IP licenses.
All the same.
Thank you. Before we start, I'd like to thank our parent company, Docusign, who has made it possible to bring this webinar to you for free. Here's a short video about Docusign's Intelligent Agreement Management, or IAM platform, designed to help organizations unlock the full value of their agreements.
Today, what we're going to talk about, first, just very briefly, why this is such an important topic. I think most of you will know that, but we're going to talk about that anyway. And then we're going to dive right into what are the elements of a typical limitation of liability clause. And it's really a lot of different clauses in one. You've got typically a disclaimer of consequential damages. We'll talk about that one separately, and then we'll talk about your typical ordinary cap or liability cap. And we'll talk about in great detail what the exclusions and exceptions and carve-outs are to that cap. And that's where a lot of the meat of the negotiations happen, is negotiating those exclusions. And then we'll also talk about super caps and when they're appropriate and when you're going to have them. And then we'll also touch on some other negotiation tips. And I see a poll has popped up while I was going through the agenda. So we'll give you guys a couple of minutes to answer that and we'll take a look.
Well, it
What
looks
you
like we have a lot of great responses coming in. Thank you for submitting those. I like to always have some predictions on this one, but I was like, I'm going to let this one go. Let's see what happens. All right. We're almost there. Almost everybody has taken it. So we're
Yeah, and the
almost
question
there.
is which of these issues do you negotiate the most? And it looks like the liability cap is the winner by a little bit, and then of course the exceptions and exclusions. A little surprised by that because the liability, maybe there's a terminology gap because the liability cap itself, I usually see it's more the super cap, if any, that gets a lot of
Mhm.
negotiations. The ordinary cap is pretty standard. So maybe people were thinking I was talking about the super cap when they said the liability cap. So um, we're ready for the next slide. Okay, so why is this important? So regardless of the contract itself, context always matters. The context of the deal, is it a big deal? Is it a small deal? Who's doing what? Is it a vendor contract? Is it, for advertising? What are the terms and conditions? Who's doing what? But regardless of whether it's a small deal or a large deal, the liability caps are exactly what they sound like. They cap parties' liability. So they'll tell you whether it's a big cap, a small cap, no cap. That's going to tell you what your ultimate real world responsibility is. And that's why it's so important. You could have a tiny deal to buy $5,000 worth of software or services and get dragged into a $10 million lawsuit over infringement. That has nothing to do with the size of the deal. And that's why these caps are so important. If you don't pay attention to them, you could inadvertently be getting yourself into a lot of liability when you're not expecting it because, oh, it's a small, low risk deal. I'm not too worried about it. But you still have to review, at the very least, the liability caps. So that's one of the reasons. And again, the liability has nothing to do with the size of the deal. And I'm sure a lot of you have experienced this as well, that it's often one of the last issues remaining. And for that very reason, because that's the crux and the meat of what's your exposure. And then on the next slide, I think Mike's going to kick us off with on the next slide with talking about the cap, the disclaimer of damages first.
Yep. Thanks, Brian. Thanks, Roma. What's up, contract nerds? Um, just quick disclaimer here. My views are of my own, not my employer's. All right. So this probably look familiar to a lot of you. You'll see this in contracts, see a big chunk of text. The parties are not liable for consequential, incidental, indirect, special, punitive damages, lost profits, lost data, etc. At some point, you've probably seen a simpler version of it. It just says, not responsible for consequentials or indirects. Think like, okay, this is just a laundry list of these things. Why does it have to be so long? Um, but there's a reason these are all listed out, is because parties don't always agree on as to whether or not something is quote unquote consequential or indirect. There can be all kinds of arguments about, oh, well, this is direct, this is not indirect, depends on the circumstances. So you don't want to have those arguments. It's really, really important to make sure you list out every single possibility, right? And these laundry list items basically usually do that. Um, because you never know if someone's going to try and make a wacky argument. I had a counsel once try to make the argument that lost profits actually were direct because if something happened and there was a press release and their stock went down, then blah 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 lost profits, right? And of course, he had to give me like 5 steps to get there, which immediately undercut his argument. Um, but then part of me wanted to say, okay, but when the stock price goes back up, do we get a refund? So he didn't really like that. So you never know what kind of arguments people are going to make. So these kind of lists, and this is a bit a larger pro tip for contract drafting. Define terms are the best way to protect yourself. You don't want to have any argument over what something could mean. And in liability in particular, that's really important. So this is the first place it's going to come up in this presentation, but I think it's really important. So, all right, so you go to the next slide. Where's the button? All right. So why disclaim these damages, right? Um, the most important argument to make is that they're unreasonable because they're unpredictable. The context of the deal matters, as Brian said. When you're looking at a liability claim and trying to say, okay, how do we calculate this? Usually there's some, you have to look at the context, you have to look at the value to the client, the dollar value, all these things, but there has to be some level of predictability, right? If it's something where you're handling sensitive data, you can look at the raw data, say, okay, if I release this kind of health information, this is the dollar amount of these fines, right? Or this is how much it costs to send out a notification. For some of these consequentials, who knows what it could be? There's no way to predict it. There's no way to price it. So it's unreasonable to accept the unknown. Um, because it's so hard to put a value on, that makes it inherently unreasonable, and that's why people almost always agree to, you know, disclaim all these different things. Go to the next one. Okay, so I talked about this a little bit. One court may, courts aren't always consistent, right? One party may say it's consequential, the other party may say it's indirect. We say, what's the difference here? Again, lost profits is another one where, if you can try to point directly, say, okay, this happened, profits went down. Sometimes you can draw something a little bit more direct. So that's why, in particular, it's really important to disclaim that one. Um, but again, defined terms are going to protect you here. The best way to protect yourself, make sure you've defined, list out every potential possibility. You don't want to get too detailed, but I think most boilerplate terms will have yourself covered. But if there's something quirky about your deal, something you're worried about, feel free to add stuff too. There's no rule of what you can't add to it. All right. I think that's it here. So you can go to the next one. Oh, okay. So confidentiality and data breaches, that gets a little trickier because uh, almost by definition, any kind of confidentiality damage or data breach damage is going to be consequential because there's going to be a ripple effect. If someone's information gets out, someone's personal information gets out, someone steals it, someone opens up a mortgage under their name, that has steps, but at the same time, if you disclaim consequential damages for confidentiality and data breach, there's almost nothing there to cover. So with these kind of damages, being totally shielded from any damages whatsoever from these things usually doesn't fly. And it's not reasonable. So if you're going to agree to consequential damages for these things, it's still the best way to protect yourself is to define it. Usually with the data breach cap, say, okay, for breach of confidentiality, breach of data, damages are limited, okay, it's carved out of consequentials, but damages are limited to notification costs, government fines, credit monitoring, etc. And even better if you can get it, a dollar amount. That way you still have a level of predictability, even though they're consequential damages. So this is one area where more often than not, you're going to get them. But something I like to do also is, even though you have those things that are technically consequential, I still like to disclaim speculative damages because those are still known. The cost of the cost of mailing out these things or setting up a call center, those are known costs that you can find easily. But anything else speculative, that it's not reasonably responsible for. So as long as you put tight boundaries around it, you'll be well protected.
Yeah. And if you don't, I would add to that. So, and a lot of these issues interrelate. So we'll talk about this more when we get to the exclusions section.
Mhm.
But confidentiality is a tricky one in that, just for all those reasons that he said, because it really, if you think about what's the direct damage from a data breach, somebody's processing all your client email addresses. Let's say you're a retailer and you give them 10 million email addresses to process somehow, and there's a data breach and all that information gets out there, or maybe they lose them. What's your direct harm maybe is just, well, geez, how do I recover the data that's been lost? That's not the big deal. The big deal is the consequence of that being leaked. Now there's a privacy lawsuit. Now the government is coming after you for a privacy breach. Each of the end users, each of your customers is now suing you for breaching their privacy. That's more a second tier consequence. And that's why this one's tricky. Now, you don't want that not to be covered. That's why confidentiality, you'll see when we get to the exclusions, is often handled separately. And that's why you see these very detailed clauses that say, hey, are we liable for the cost of the remediating the data breach? Are we liable for credit monitoring for people whose data has been breached? If, maybe it was a credit card number or something. But you'll see when we get to the later section, this one's very confusing because it is indirect, even though it's still something that you would want to include 9 times out of 10 if you're the customer. I think we're ready for the next. And now that we've talked about the disclaimer, we're going to talk about the first level of caps in a typical agreement. And, to caveat here, we're always talking about a typical agreement. There's no such thing. Context always matters, and no two deals are the same. But most deals will have some structure similar to this. They'll have a disclaimer of consequential and indirect damages, and then they'll have a cap that says, this party or that party or both parties' liability is capped at X amount. And those are very common clauses. I'm sure you see them all the time. Typically, it's a dollar amount. Maybe it's a multiple of the contract. Maybe it's, 12 months worth of fees or something like that. Sometimes it's 6 months worth of fees. And typically, not all the time, but typically, if this is a vendor-customer type of relationship, a vendor would prefer lower caps and a customer would prefer higher caps. And the reason for that, if you think about it logically with common sense, a customer is buying a product or service or some sort of processing from a vendor. The vendor is doing the work. The vendor is providing something that has risk. Maybe they're processing data and that they could have a breach. Maybe they're providing software that could infringe. They're doing something or providing something that brings the possibility of liability. The customer, on the other hand, is just buying it and paying for it. So what's their risk? It's a lot smaller, typically. Again, there's always exceptions to that rule. Customers can bring liability too. So for example, again, in that case where it's a customer list, do you have all the consents and opt-ins to share that list? Are you violating some law or privacy rule or confidentiality by sharing the data that you're dating? You're sharing? Do you have the right to share that data? So you have to look at the context of the deal when you're representing somebody and say, do I want a high cap or do I want a low cap? Let me see what position I'm sitting in and let me think about this for a second. What could I do wrong that could harm the other party? And what could the other party do wrong that could harm me? And look at that context to decide. Another example where sometimes, it's actually the customer that might prefer a lower cap. An advertising deal is a good example. If you think about it, if you're buying ads from a publisher, you're technically the customer, but a lot of the liability is based on the content you're providing for the ad. You're going to provide ad copy, you're going to provide your logos, you're going to provide marketing messages, you're going to provide a claim that, my product is better than their product. Is that a false statement? Is that false advertising? Do you have the rights to, is your content, the content for your ad, did you plagiarize it? Is your logo, does it infringe somebody else's name or logo? So the content of the ad could pose a lot of liability potentially. So, again, the key takeaway, if you remember one thing from this slide, is context matters. Before you start thinking about what the caps should be, what the carve-outs should be, what the exclusions should be, what the super cap should be, the very first thing you should do as a lawyer is think about who's doing what for who and who could cause what liability. And therefore, am I better off with a bigger cap or a lower cap, a super cap or uncapped? Am I better off with more exclusions, fewer exclusions? You've got to take that into context in every deal. Next slide, please. So that's always important to always remember the big picture. So things to think about. Is the cap mutual? A lot of times you'll see a vendor send over a contract that disclaims the liability for the vendor, but not for the customer, particularly in click to agrees or places where the vendor has a lot of leverage. It's Salesforce or Google doing a deal with a startup. You're going to look at their template agreement and it's going to say, my liability as the vendor is completely capped and yours is not. We're only liable, the maximum we could be liable for is 6 months worth of fees for the particular services at hand under that particular SOW, and your liability is uncapped. That's a very common thing. So look, is it mutual? should it be? Again, with the context of what seat you're sitting in and what you're doing. How long is the look back period? Is it a 6 month cap? Is it a 12-month cap? And is the amount reasonable? So another poll just popped up. Should the clauses be mutual? Always. It's only fair. Never. Each party has different risks, and it depends, which is the favorite answer of all lawyers everywhere, right? And it depends is winning to a large degree, right?
So it depends. It's interesting you mentioned that, Brian, is when it's made mutual, it's always almost the same dollar amount. But if you think about it, the risk to the vendor and risk to the client are usually not the same. So it'd be interesting to see if anyone ever tried to have different caps for the parties. I'm sure, aside from being uncapped. But it's I guess that's where the super caps and exclusions and all that come from. But it's kind of funny
Yeah.
that the gut reaction is to just, change one party to both parties.
But
Yeah, and that's true. Oh,
I'm
go ahead.
surprised to see that there's so much it depends, right? I mean, we live in a time we've seen so many of these contracts, the types of transactions. I'm surprised and a bit disappointed that that's such a high number. I know people are also trying to be funny, but it can't always be it depends. Like there's enough transaction, enough data to know that if it's a software agreement or if it's a services agreement, we will not be, it can't be this out, in the flux. So I urge everybody who said it depends to maybe think again and see, where maybe it is and it isn't. So
Great point. I mean, it does depend, but there are general rules. So in X type of agreement, maybe the standard is this, and in Y type of agreement, the standard is that. So yeah, in the macro sense, when you're saying in any contract, what should the caps be mutual? Of course, the answer is it depends. But if you're talking about a SaaS software license for XYZ type of, marketing or IT services or software, then maybe, okay, yeah, it's probably going to end up being mutual.
yeah, but then,
And
it's a good philosophical question as well. Like, why would it ever be unilateral? Like, shouldn't everybody bear a little bit of burden? And always everybody has a limitation of cap. Like, one party cannot. That's just my, let's think about that after this poll as you finish. So more like, let's pause and think, maybe we all strive as a legal community to have a mutual limitation, whether it's 90 to 10% or 50-50. We're not saying that, but everybody
right,
bears some responsibility in capping the limitation, right? All
fair
right, well,
point.
this was a great poll. Thank you so much for all the results. Looks like the results are done. All right, let's move forward with the presentation.
Yep. And so a couple of traps to be aware of, and we'll show some language on the next slide, but before we get there, some traps to be aware of is it based on fees paid by the customer or fees payable by the customer? It can be a big difference if the customer hasn't paid yet. Maybe they're supposed to pay $1 million and they paid none of it. All of a sudden the cap is zero. So look for that language when it says based on the last 12 months fees paid. A lot of times you'll see that red line, fees paid or payable. Is it only for a subset of services or for the entire agreement? This is another way I see vendors sometimes trying to narrow the cap, the size of the cap, particularly when you're dealing with a big vendor and a small customer. The first draft might not only be unilateral, but it might also say the cap is 6 months times the fees for the applicable services under the applicable SOW. So, right, if you're doing an agreement for 20 different types of software and tools and deliverables, and then they have a breach under one of them, it's really only the subset of fees for that sub-service under that particular SOW that is the cap, as opposed to it's the amount of all payments in the last 6 or 12 months. So look at that one too. Um, Another
Brian,
one,
real
oh, go ahead. Did you have
Yeah,
something to say,
real quick
Mike?
on that point before we get past it from the vendor
Yep,
perspective, of course
yep,
that makes sense, right? Because if you have these evergreen agreements with clients that, these master agreements that live on forever, you might have a small statement of work that's worth $100,000. You might have a massive one that's worth $20 million. The cap should still align with the particular work, right? Because otherwise you'd have liability for the $100,000 contract that becomes $20 million. Also, sometimes
yep,
if it's all damages under the agreement, if it's evergreen, it never expires, never terminates. The cap just keeps growing and growing and growing over time. Some of the contracts we have with clients are like 20 years old. The cap would be like astronomical. So there are good reasons to draft it like that.
Agreed. And unless it's tied to a time frame, like the last 6 months fees, the last 12 months fees. But to your point, big versus small SOWs, it's still there is a reason why you would want it to be linearly tied to that. A breach under a small SOW shouldn't expose you to the same level of liability as a breach under a big SOW. And I
Yeah.
totally get that and agree with that. Um, so one question that comes up sometimes, people always ask, hey, if it's fees paid in the last 12 months and we're in the first month of the deal and something goes horribly wrong, isn't the cap effectively zero because nothing's been paid yet? No payments are due yet. That's technically true, but it's also not necessarily a problem. And here's why. Because again, this is the ordinary cap. We're not talking about the super cap yet. Remember, in context, we're talking about direct damages for something the other side did, and maybe the products or services weren't up to the right quality, so you need your money back. That's a typical use case here. The ordinary cap typically applies for things like warranty claims, for failure to deliver, for, I paid for this service and I didn't get the service I thought I was getting. Give me my money back. That's why it makes sense to tie it to the size of the deal and not some larger number. We'll get to that when we get to super caps. What if it's an infringement claim? What if it's an indemnity claim? What if it's a data breach? Those are a different bucket typically. And so keep that in mind when you're thinking about the ordinary cap. It makes sense to be only 6 months or 12 months worth of fees under this SOW. And even if you're only 2 months in and it says the cap is the trailing 12 months worth of fees, maybe it's okay that it's still only 2/12 or 1/6 of that cap because we've only made a couple of small payments so far. Maybe it's okay because again, these are direct damages. Now, sometimes it's not. I've seen situations where a customer will mark up the red line and say, yeah, it's typically 12x 1x times 12 months worth of fees. But if we're in the first month, then you would take the average of what would be a typical month and multiply that by 12. And we'll see a sample of that on the next page. The other thing to look out for real quick before we turn the page, what about self-contradictions within an agreement? That's something that you've got to be careful about. Like I said, these clauses interact with each other a lot. And so you will see situations where, let's say you have an indemnity that's a non-infringement indemnity. And then let's say the indemnity is uncapped, but you have a super cap on infringement. Which one governs? Because you've, on the one hand, said infringement is uncapped because it's part of the indemnity, which is uncapped. And on the other hand, you said it's capped. So that's a self-contradiction. You have to have an order of precedence if you're going to do something like that. You see that the same with an indemnity for a data breach, and then one of them, and then data breach is capped or uncapped, and the indemnity is capped or uncapped, and they're different. So watch out for those internal inconsistencies. Same with external documents like a DPA, a data processing agreement or addendum. You might have a data breach clause that's uncapped in the DPA, and then in the main agreement it says, and there's a cap for data breach of a super cap of $500,000. Make sure you're being internally consistent because all these provisions interact with each other. We'll see a sample on the next page that I think, if I'm remembering the order of these slides right, I think there's a red line on the next page. Nope, there's a cartoon first. And this is a great cartoon because it's timely because of the Odyssey movie. But this is a perfect example of that, where one clause says one thing and another clause says another thing. And it's kind of like a Trojan horse that makes you liable for something you didn't think you'd be liable for. I don't know who, Mike, was this your cartoon? Where did this
That's
Rome?
not mine. I like
No?
it though, and it's a good analogy sometimes for large complex contracts with different exhibits. Oftentimes, data security exhibits will have little liability disclaimers popped in there. And that's where the order of precedence, usually you like things like exhibits or attachments or statements of work. You want them to win in the event of a conflict. Well, I mean, the vendors do. If there's these weird uncapped liabilities that are hidden in there, it can actually be bad. Um, so you have to really make sure that you're combing through these to make sure there's no Greek
The
warriors hanging out in your data breach clause.
the meme credit goes to Nate Kostelnik, everyone. He is
Okay, yeah.
your editor for webinars and content, and he is the meme king, as we know that. So
He's
thank you, Nate,
great.
for this appropriate meme for this webinar.
Thank you, Nate. One of the great reasons I love working with contract nerds, like I wrote a lot of slides, but then great cartoons pop up in the middle because of something the editors do, which is great. I love it. Thank you. And then the next slide, I think is, yeah, there's where a sample, or first sample red line is. We're going to have a couple of different sample red lines throughout. Here's one for liability caps. This is a hypothetical where you're a customer and you get a one-sided contract from a vendor and it caps only their liability and it's only 6 months worth of fees, not 12. And it's only the applicable services. This would be a sample red line that, a customer might want to do, again, based on the overall context and assuming that the customer benefits from a larger cap and a vendor benefits from a smaller cap and making it mutual. And you can see the language fees paid or payable as a sample like we talked about. Mike, do you have anything to add before we go to the next slide?
No, I don't think so. I think we covered it. I know how I'd respond to this red line. I think we didn't also talk about this though, the having the greater of number, but that dollar amount. The dollar amount normally is essentially at least when I do these contracts, basically the anticipated value of the deal. Um, that's how you come up. Sometimes it's like there's like a standard floor, like $100,000 or something like that. But the value of having that is really kind of setting the stage for how much you think the deal is really worth. And then, it depends on the type of contract, whether or not the monthly fees could vary. But it's good to protect yourself by having this as a reasonable number. Because if you just have it as like a low floor, it doesn't really do anything.
Yeah.
Um, but if it's the kind of volume where the volume may dip below your anticipated usage, this number can actually protect you. So
Yeah.
it's not something to just brush over.
Yeah, a couple other things real quick. I'd also say more often you would see the greater of a dollar amount or a multiple. That's more often going to appear in the super cap than in the ordinary cap, but we put a sample of it here
Yeah.
just to show it. But typically this clause is much more simple. It's just shall not exceed the last 12 months worth of fees paid or payable is a pretty common structure for the ordinary cap. And again, keep in mind, the ordinary cap before any exclusions that are uncapped or super capped is really the direct damages. So it's really typically the things that are just, I need my money back under the warranty or something like that because you didn't fail to deliver or you failed to deliver the right quality standards. It didn't meet the specs. So you don't really see big caps here. Although I have seen, and this is interesting, I don't know, Mike, if you've seen this, I've seen a lot of times instead of having a super cap, I've seen some people write it so that the ordinary cap is really big. Instead of like 12 times the fees, the ordinary cap is $1 million or $5 million, and then there is no super cap. That's odd to me because there really is a difference between the two. But have you seen that a lot? Is that something you've come across?
Well, it depends. I mean, some of the contracts I do are pretty big, so I don't know. Maybe but yeah, I see those high numbers, but um yeah, I guess instead of a super cap, they just make the whole thing big. Normally it's you see like 2x, 3x, 4x, those kind of things. That's where it starts to get a little bit out of control. Um, so that's when I see the numbers get really high is with those multipliers. Sometimes I've seen clients ask for crazy amounts of money, but usually those are on like bigger deals. Like I've seen $100 million proposed cap on a $50 million deal, but again, that's like 2x. So it's not, you see the big dollar numbers, but you got to think about the context. Maybe it's hypothetically not unreasonable.
Okay, exactly. Okay, next.
All right, so I'm going to pick it up here. So I think we agreed. I mean, other people may disagree, I guess, but this is where usually the most meat of the argument and negotiation between the parties is all these exclusions, exceptions, carve-outs. Um, first one point, sometimes parties will have it be only carved out from direct. Sometimes they want to carve it out from both. Sometimes, depending on how long negotiations go, sometimes some things are carved out of one, some things are carved out of both. Depends what's important to who. And oftentimes you'll hear customers say, "Oh, we always have this carved out." or vendors will say, we never, ever agree to that, right? This is a pro tip. Never use the words always or never. Because if the deal is important enough, even dollar wise, even if it's important enough, to a particular executive, to a particular relationship, there's a press release scheduled in a couple of weeks with the governor of something, and you want to get something out. There's always a reason somebody will sign off on that. And from pro tip for your practice, if you say something's never, and then it gets overturned, you've lost your credibility. And that hurts you both in the current negotiation and as the deal goes on, if there's anything that pops up in the middle. So lawyers like to, say, oh, it depends. You don't want to say it depends that we'll ever agree to this crazy uncapped thing, but you need to couch it to the point of saying basically never. So that's just a
Or
key.
something like, I've never seen us given this point before, but there's
Yes.
always a first time.
I've
We'll
I've
bring
never
up the
seen it. It would be the
flagpole.
first time, et cetera, et cetera. Yep. I think that's good. Okay, you can go to the next slide. Um, all right, so here's some of the typical ones you see for customers. We've talked about this: breach of confidentiality, data breach, security incidents. Again, where the high damages can make sense. This is somewhere where, again, if you do have to agree to these things, you should try to get caps on them. For breach of confidentiality, one way I try to approach it is to limit it to specific bad act by at least in my case, by the vendor. So saying, okay, let's say we misuse or misappropriate your confidential information. Those are things it's hard to defend, right? But if you say something generally about breach of confidentiality, and it can be read as if you don't follow your own standards and a hacker gets in and the hacker discloses all of your information, that's not something you did per se. It's an omission, but is that something that should be totally uncapped? That's where it gets kind of fuzzy, and you should really tie it to bad act by you. Because again, they're talking about direct, indirect. If someone got in because you didn't do something and then they did this and they did that, that's consequential and you shouldn't be responsible for it. So I like to be creative in these things and think about all these worst case scenarios, but it turns out to be really helpful when drafting these kind of things.
Yeah. Sorry to interrupt, but a phrase like "to the extent" can carry a lot of weight in these types of
Yes.
clauses. So, a breach of confidentiality to the extent caused by the vendor or to the extent due to the vendor's negligence or fault, right? Because that's a perfect example. A super hacker could get in even if you're doing everything right, but if the hacker got in only because you didn't follow reasonable industry standards, that's a different story. So, whose fault was it that this got hacked? Was it unavoidable or was it the vendor's fault?
Right. And even, industry standards aside, which is a vague term we vendors don't like, there's no such thing as being hacker proof. Especially now when, the OpenAI bots get bored and decide to hack Hugging Face. Like, there is nothing that is hacker proof, especially not AI. So, you can never assume you can tighten things up all you want, but someone can get in. So tying it to your specific data security obligations is definitely key. And that's another good way to limit the clause, saying we're liable, in the event we breach Exhibit E data security, right? So if you breach those specific things, then you can be liable. If a hacker breaks in, despite the fact that you had all of these things selected, you had all the things up, there was some backdoor that you didn't know about. It doesn't make sense for you to be responsible if you've done everything you're supposed to do in that exhibit.
Yeah. And the other thing I'd add, not to sound like a broken record, but the reason why this says what customers typically want with a star by it is because typically a customer is going to want the vendor to be, have higher liability if they have a data breach, a confidentiality breach, an IP infringement, because typically the customer is giving data to the vendor as a typical relationship to process. And typically, the vendor has some technology or IP that's at risk of infringement, but not all deals are the same. What if it's a deal where the customer is giving its IP to a professional services provider to do some work with? And really, the bigger risk is the customer's IP infringing, because whatever you put here is probably going to be mutual. So if you carve out of the cap IP infringement, it's probably going to be mutual. So again, put on your hat, what's fair, what's context, who's doing what. If you're representing the customer, is this one of those weird situations where the customer might be providing more IP, or the customer might be getting more confidential information or data from the vendor for some reason? So these are rules of thumb, but even rules of thumb have exceptions to them.
Yeah. And the vendor IP infringement indemnification, that's where it really makes a lot of sense to be, excluded from the cap, not only because who knows what it could be, also from a logistical standpoint. If you have a cap on it and halfway through the litigation you hit that cap, the vendor just going to walk away and be like, okay, here's outside counsel's phone number, you go figure it out and start paying them, right? It's hard to switch that up midstream. But again, it's also indemnities outside the scope of this, but it's really important to keep IP infringement in mind in terms of damages, because it's hard to justify that kind of liability, because especially now, if you have IP that you've worked into your workflow and all of a sudden you've got these third-party claims, aside from the fact that you're getting sued by some patent troll, all of a sudden something you've been relying upon, all of a sudden you can't use. So you might have to go and do, God knows what, to try and pull in something else, try to rework it. It can be a big headache. So having to fend off those third parties should be the least of your concerns if it's disrupting your entire organization. So, okay, then we go to the next one, see what vendors. Hey, what you were just talking about, Brian, the customer infringement identification. This is more also if they infringe your IP, right? You're the vendor, you give them something, they have a license to do one thing, and then they go and do something totally different with it. IP infringement is another one. It's when IP infringement happens, sometimes you can't unring the bell, right? Once it gets out there, once it's in the public sphere, once it's used a certain way, it can proliferate, and someone who didn't have a license to use your stuff originally can get a license from someone else. It's hard to claw all that back, especially if something gets dumped into GitHub. So you never know how something's going to pan out. So that's, putting a cap on that is definitely unreasonable. Breach of payment obligations. This is an interesting one where sometimes you get arguments, because it's reasonable to say, okay, you owe me these payments, right? We have a payment schedule. It's a 3-year payment schedule. You shouldn't be able to just walk and only be responsible for 12 of the 36 or whatever. But the other party will argue, well, that you said the cap is 12 months fees. So you've recognized the fact that, you're only going to get X amount. But that's not the case. And that's where I was coming to before, is like the mutual cap. You just come up with this number based on 12 months fees. But the amount you're owed and the amount of damages you suffer due to a client doing something are two different buckets. And you shouldn't let another party throw you off, because they really are two different obligations. Because if the amounts paid isn't carved out, they can cause you a whole bunch of damage and be like, okay, well, I'll pay you what I should have paid you, but your house is burning down. It's not my problem anymore. So you need to make sure that you're able to collect what you're owed and be compensated for other damages those parties cause. Breach of the use restrictions, license scope, talked about that. Basically the same thing with IP. That could be overage usage, though. I think more so with SaaS now, it's harder. It's not as much of a problem. I know with IP, with tech companies, they used to have to go and look at licenses, have to go and audit, be like, okay, you bought 100 copies of Microsoft Word, but you have 500 people using Word at your company. Some of those kind of fees, some kind of those structures, it made sense. But now with SaaS, I think it's a little bit harder to manipulate. Not that it's
Although
impossible.
sorry to interrupt, but I would add that now with AI, you're starting to see more and more SaaS deals, particularly AI deals, that do have usage requirements. How much are the tokens, right?
Hmm.
So you're seeing more usage-based fees creeping in.
Yeah, for sure. Yeah, it's especially if you don't have good metering and all of a sudden you have some guy who turns on Fable. I was using Fable for something and I asked it to do one simple thing and it deployed 103 agents and burned through my tokens in 4 minutes. It was wild. So these agents are getting to the point, these models are getting to the point we really need to like make sure you're keeping a close eye on. All right, you go to the next slide, see what both parties want. All right. Death, bodily injury, property damage. I've only had someone try to disclaim property damage once, but normally it's hard to argue that these things should be disclaimed with a straight face. Um, so normally this is never really an issue. In general, states are probably going to have, if they don't have explicit laws about it, there's going to be some kind of public policy argument that can be made pretty easy, saying you can't be liable for the death of, you can't have uncapped liability for causing someone death. So it's hard to come, I like to use my imagination to come up with scenarios. It's hard to come up with scenarios where someone gets killed due to us, like, doing some kind of document retention. But you never know. Violation of law, fraud. This is one that's a little tricky. I mean, you can't necessarily contract around your obligations under the law. But it's another thing to say whether or not your breach of your legal obligation caused a damage that itself should be uncapped. So make sure that it's really tied together and not some, normally it's a compliance with law obligation or the contract saying, okay, you have to comply with the law but if you tightly bound to say that apply to you under this agreement, the services you're doing, that way that, when you're the vendor, the customer's legal obligations that have nothing to do with you or that they're responsible for don't creep up on you and become your liability and your problem. So that's a combination of careful drafting, making sure that your compliance with law obligations don't sign you up for damages you shouldn't be liable for in the first place. Um, then fraud, gross negligence, willful misconduct. This is where you need to be really familiar with your state's law on these things. Some states say you can't cap these, otherwise some states are silent. Some states a little bit more flexible. What I really like to do is if there is a legal definition of these things, use that legal definition. So gross negligence disclaimed. Gross negligence means just rip it straight out of the statute or case law. So that way a party can't try to argue that what you did is gross negligence versus negligence, because otherwise, anytime there's anything that remotely looks like negligence, the other party's going to try to argue that it's gross negligence. Right? Like, don't get me started on gross negligence. Kind of the idea of negligence versus gross negligence in a contract is nonsense. Right? You either breach a contract or you don't. It doesn't matter how negligent you were or how grossly negligent you were. Breach is a breach, the associated damage is a damage. Right? It's
And back to the repetitive theme that it really all these things interplay with each other, and there's a lot of overlap between clauses. I would add that this is another one that goes in that bucket. So, for example, it could be gross negligence or willful misconduct if you steal somebody's IP. That could also be IP infringement. So you might have it in two separate clauses addressed two different ways. So look out for that. If you just inadvertently leak somebody's IP, maybe that's just an ordinary breach and maybe it's an ordinary infringement. But if you purposefully steal somebody's IP, you steal their secret recipe or try to, study their product to build a competitive product when you're not supposed to, that could be intentional. That could be willful misconduct. So it could fall under multiple different provisions of the contract. Thou shalt not compete. Thou shalt not infringe. Don't do anything with willful misconduct. And it's three different places in the contract with three different standards adhered to it. Look out for those things.
yeah. Yep. All right. So here's a classic word salad of stuff you'll see getting dumped in here. It's a favorite where I look at the original red line. I look at the original contract page count. and then I opened up the red line page count and it's like double. Like, oh God, like someone's just doing copy and paste. Like, especially not to hate on uh big outside law firms, but they're the most guilty of it, right? Just drop in all this stuff. Or procurement groups are like, oh, that doesn't read exactly like my liability clause, so I'm gonna cross out the whole thing and then drop mine in. Perfect. It's
Or
just
some AI tools do that. There's some that are notoriously
yes,
good at
yes. They're getting
precision
yeah,
red lines versus striking out a whole clause and inserting their whole preferred clause. So play
yeah.
with the different tools and see. I like to play. I don't know if you guys have ever heard of it's showing my age a little bit. The game show Name That Tune, where contestants had. I could name that tune in 2 notes or 3 notes. The quicker they could do it, the fewer notes, the more points they got. It's the same with redlining. You should challenge yourself every time you write a red line. I need to say this, but can I say it in 3 words or fewer instead of a paragraph? Because it'll just for optics, without compromising, as long as you can say what you need to say, try to do it in as few words as possible and constantly challenge yourself to do it in a lighter red line.
Use a scalpel, not a chainsaw.
Yeah.
One of my favorites. Um, yeah, so you see how these things get added, mutual either party, 11 months term, 12x average, so some of these things kind of reasonable, but all of these things, it's better. I like to just have like bullet points like the following exclusions A, B, C, because when everything's also like in all caps, it's kind of a pain to look at. Also, I don't like it because then when it's read like this, like I can't spell check it when it's all caps like this, and then I end up making a stupid typo, and it's the worst.
Yeah.
Because
So
thanks
I
to
think
spell check, I can't spell anything anymore.
does that take us to super caps next, if I remember
I
right?
think
Yep.
so, yes.
So, and super caps are pretty important too. That's also where a lot of negotiations happen. Now that we've decided to carve some things out of the typical cap, we're going to put back on a super cap on them. What is a super cap? Very simply, it's just it's just a secondary cap that's bigger than the ordinary cap but smaller than unlimited. So a typical example is, you know, data breaches aren't subject to the ordinary cap, which is only 12 months worth of fees. So by saying they're not covered by that, is it unlimited liability, or are you going to put a number on it? $1 million, $5 million, $10 million, $500,000. So if we go to the next slide, when you start to think about how much should it be, this is another one of those where context really matters a lot. Um, oh, we got a poll. Okay. What is your go-to super cap? 3x, 5x, 10x, $1 million. And by the way, those aren't the only options. I've seen $10 million caps. Again, if it's a consumer product and it's a retailer who's giving 10 million customer files to the vendor to process and target ads, you leak 10 million names, you've got a big privacy lawsuit that could cost you 10 million bucks,
See,
right?
this is where I would come in and say it depends should be an option. This is what I want, it depends.
Mhm.
I always wonder sometimes if they throw in an absurdly high number, it's like, why bother ask for a number? Because at this point, it's basically uncapped because you're never going to hit that cap. So,
Yeah. So, and then there's also even with data and privacy breaches, I see everybody says, "Oh, privacy breaches are so expensive, so you got to have a huge cap." I've been on both sides of the table. I've represented customers, I've represented vendors, so I've seen it from both sides. And again, not to sound like a broken record about context, but you could be doing a software deal where, again, it's a retailer that has 10 million client names and email addresses and credit cards, right? That, yes, a privacy breach there could be tens of millions of dollars. Or you could be doing a B2B tool where the only 3 people using it are going to be employees of the customer company. And yeah, you're going to technically have personal information because you're going to have their email address and their IP address. So technically, you might argue you need a DPA or there's personal data involved. But if there's a personal data breach there, I mean, you're talking about 3 people's emails. So you got to always remember the context and what is being, exchanged. So just because privacy is invoked doesn't mean it's going to be a huge liability. Next slide, please. So what is a super cap? We already talked about this. It's a second higher cap. It's usually because of a compromise, because the vendor may not want unlimited liability for infringement or indemnity or data breach, but the customer obviously doesn't want the 6x or 12x cap. So let's go to the next slide. Um, so what's the appropriate amount? We talked about this too a little bit. It depends on what the context of the deal is, who's doing what for who, what's the risk, and which thing are we talking about? Are we talking about a data breach? If so, how much data? What kind of data? Is it personal information? Is it trade secrets like my secret recipe? Is it credit card data and banking data, or is it just emails? What is the data involved? How much of it is it? And then the same for infringement. How likely is an infringement claim? There's a very big difference between using somebody's software publicly on your website. Let's say it's an e-commerce shopping tool and you're using one click to buy technology, and some privacy troll can go on the internet and see every company that's using that technology and have a mass lawsuit against everybody who uses it, versus let's say it's software you're using internally for a database management tool or something. No one's even going to know what's the likelihood you're going to get sued for that. So context matters not just for privacy breaches, but for infringement breaches too. What's the likelihood that not only that this infringes, but that you're going to get caught as a user, right? Because if you're just using someone's software, are you going to get named in the suit, or is it just going to be the vendor? Things like that. So we've also seen a lot of times, sometimes people will try to tie the cap to the amount of insurance. And there's some theoretical logic to that. People are like, look, if I've got $10 million worth of insurance, then I don't want a penny more than $10 million worth of liability, because I want it to match, because I want my insurance to cover. The problems with that, the fallacy that is, there's several. One, you know, is all of the insurance available? If you're a vendor and you have $10 million worth of insurance and you have a data breach, each client of yours isn't going to have $10 million of coverage. You're going to have $10 million of coverage total across 1,000 clients. So the cap tied to the insurance, is that real? Is that insurance actually available? Also, which insurance are you talking about? Are you talking about their GL insurance, their general liability insurance? Or are you talking about their cybersecurity insurance? Or are you talking about their umbrella policy? Or are you talking about all of the above? I've seen people throw in clauses that say it's tied to the amount of insurance without being specific. And then there later is litigation over, well, which insurance are you talking about? The one with the big cap, the one with the small cap, adding them all together, and arguments ensue. So, I'm not a big fan of tying it to insurance for all those reasons, but some people do like that. But if you do use insurance as the guide, beware of those traps. Let's go to the next slide.
Well, I would say you also need to know your insurance policy, because a lot of insurance policies are explicit that you can't do that. You can't tie them to the liability, because that basically makes the insurance company a party to the contract, right?
Or
So
there's
they'll
or
be
there's
like,
things carved
no,
out of the insurance, like yeah,
yeah,
your data breaches are not data breaches are carved out, but your misconduct is carved out, and then all of a sudden some hacker gets in because you didn't meet industry standards. Is that actually insured against, or is it only insured if you actually took proper standards and then got hacked, right? So
right,
look at all the carve-outs and the exceptions to your insurance when it may not pay out, because a lot of times if you've done something culpably wrong, your insurance may not pay.
right.
So, and then what
Here,
happens to, you know, which things do you put under the super cap? You put everything that you've carved out under the super cap, or just some? I've seen people say everything that's excluded, all the exclusions we talked about, they're all subject to this super cap. And I've seen other times where people enumerate these three things, data breach will have this super cap. And then by implication, everything else is still uncapped if it was carved out. And both are common, both are right in different situations. I mean, think about it. The things that are going to be uncapped anyway, I don't fight about. If someone says, okay, but you can't super cap gross negligence or willful misconduct, fine, depending on what jurisdiction we're in. I probably wouldn't be able to super cap that anyway, so I'm not going to lose sleep over that, fighting that battle. But some things maybe I will. Um, it's theoretically possible to have two different super caps to say, okay, there's a 12x direct damages cap, and there's $1 million cap on infringement and 2 million for a data breach. Theoretically, you could, but that's pretty uncommon. Usually, you just pick one super cap and then figure out what things go under that super cap versus what things are uncapped. Uh,
Back, Brian, back in my outsourcing contracting days, we'd actually see a lot of that. You would have different super caps. Sometimes there'd be one cap for direct damages, there'd be a super cap for confidentiality, there'd be a super cap for data breach, sometimes for compliance with specific law, government fines. Like you could see this because every single thing got negotiated. So for whatever reason, you come up with all these different numbers. So I've seen it broken out like this, albeit they were like nine, really big deals, but it depends how many hours the outside counsel want to burn up, I guess.
and what the context of the deal is exactly.
Of
Broken
course.
record, I know, but awesome. And here's a sample red line just showing, both ways, one to carve out certain things and one to carve out everything. And you'll all this a copy of this will be available afterwards. You
Yes,
guys can
all
see
of
the
this will
red
be
lines
available.
because I
Yeah,
know
and
we're running
then
short on time. So
you can keep going. We do have some time for questions, so we'd love to make sure that you get through all the material before we get to the Q&As. Yeah.
exactly, exactly. We're getting close. So again, some tips and tricks. Should it be mutual? Again, think about the context. Oh, Mike, was this your slide? I can't remember if you're supposed to talk about that.
I don't think so. I think we've said basically all these things
Yeah.
already. Um,
I'm looking to see if there's anything we didn't touch on here. I think this is a recap, but I think we've touched on everything here. I'm just glancing at it really quickly. Again, consider your role, consider who's doing what, consider the context. But yeah, and we sort of touched on this, but the last one on the right side, map out every carve out to its bucket. It's like a logic game. You've got exceptions to exceptions to exceptions. So just think about each thing that you've super capped or carved out from the cap is which bucket does it go under? Is this something that's subject to the standard cap, the super cap, no cap, and make sure that it's not said different ways in different places, like we already said.
And make sure you can't double dip either, right? You don't want to have a particular kind of breach. You always want to say like this clause is the exclusive avenue for recovery for data breach liability, right? Because otherwise, like, okay, I used up 20 million of the data breach cap. Now let me go back to the regular one to pick up the rest, right? You gotta if you don't draft it well, then you've just increased the cap total, not
Yeah,
segregated it.
yeah, exactly.
There are a lot of questions that came in, and many of them revolved around the AI usage. How are we looking at limitation of liability? Any context on, what type of AI claims? Can you both talk about that very quickly?
Yeah, I mean, we very briefly gave one example of, where AI comes into play, but obviously that's a huge issue these days. I would say, just like we said, context matters. If it's an AI deal, what are the types of things that affects as far as what you might want to super cap or you might want to have in the indemnity, in which case the indemnity might want to be under the super cap or uncapped. So think about it. Things like IP issues. Does the vendor really own the rights, especially if they're, integrating third party IP, like they're integrating with a third party LLM? Do they have the rights to do that? And then if they have a carve out, if the vendor has a carve out that says, I'm not responsible for any third party things outside my control, is that too broad a statement if 90% of the functionality is them integrating with Claude? Did they just disclaim all liability because the whole thing is Claude? So you're going to want to negotiate those types of things, which then will have ramifications on, okay, now it's an indemnity, so now it's subject to the super cap or it's uncapped. Do you own the IP issues? Do you own the output, right? Can you even own output of an AI tool? Who's responsible for quality control problems, hallucination, bias? There's actually a lawsuit right now going on for versus Workday. I don't know if you guys have heard of this. Workday is this HR screening tool. It's an AI tool that screens resumes. And so, a lot of it's very widely used, very popular, but apparently it discriminates and it's biased. So people have sued to say this Workday AI technology, I applied for a job and it screened me because I'm a minority or I'm old or what have you, over a certain age. And so there's a lawsuit going on right now. It's still working its way through courts, but there's been some lower court decisions. And the reason I bring this up is because this is one where it said you can't disclaim liability for that just because you outsourced it. So not only is the AI provider liable for the bias in its tool, but so are all the companies that used it to do HR screening. And a lot of them tried to argue, look, I had a third party disclaimer in my contracts with people, in my terms of use that said, hey, if you apply and you use this tool, I'm not responsible for third party tools. And the court said, no, if you're discriminating, whether it's you doing it or your vendor or supplier doing it or your AI tool doing it, you still have to have a human in the loop and you still have to be reviewing this stuff yourself. So that's just one example where AI plays into these liability caps and can get very expensive.
Yeah, I was gonna say, I think they're not new issues. It's a new flavor, but they fall into the same buckets: infringement, privacy, etc. Even, sometimes there's an AI addendum saying, okay, if you use AI, you have to do this or that. Saying, okay, if you violate that, it's uncapped. So it's for the most part, they're not novel issues. It's a new cause, but the liabilities they're still there. They're not new.
Thank you so much. And then we have some questions in the Q&As here. And then again, a lot of it is going around caps and insurance. And we will actually do another session on insurance based on the demand that we're seeing right now. But one that came up, and I think it's maybe for a lot of contract professionals and lawyers who may have recently started in this profession. But there's a lot, questions came in about should there be a carve out for confidentiality and data protection? And I know it was thoroughly covered in there, but there's any suggestion, any thought for people who are new in this, who really have, just started negotiating contracts. Maybe they're the solo GC of a startup, and when they start to see these coming out, like, what would be your advice? Is there anything else that they can look at? Is there a block that they can follow to understand more on the carve outs for confidentiality and data breach?
And that's a great question. I would flip the question around and I would say rather than thinking about should it be carved out, should it not be carved out, I would think about it more granularly and think about what parts of it should be carved out and shouldn't. And that's why you see these clauses that say if there's a data breach and it's your fault, you will pay for credit monitoring and the cost of mitigation and things like that. You can be more specific. You don't have to just treat it as a end all be all and say confidentiality is carved out or it's not. Let's get more granular. Let's get more specific. If there's a data breach, who's responsible for what? And if you think about it in that lens, you don't have to worry about which bucket applies. Just say what applies to different possible outcomes.
Thank you.
Yeah, and that's what it comes to. It circles all the way back around to the beginning. It talks about reasonableness, right? It's reasonable to be liable for certain things, like, okay, like X amount of notification costs, mailing things out, paying for those stamps. But at the same time, for, your PR firm that you hire and all the, press releases they do and the commercials they put out and all that kind of like who knows where they could go. Should you be responsible for your publicity people? Like no, like who knows what you're going to go out and go do to try and protect your reputation. So there's always a balance between the known and unknown, and don't take responsibility for reasonable unknown stuff.
Yeah, and continue to follow Michael and Brian. Look at contract nurse resources. There's so much, it's such a broad topic for different industries. So we appreciate your time, Brian and Michael, today for for your sharing your expertise, and to everyone for joining and sharing your nerdiness with us. I'd like to invite you to join us for next month's webinar. It's on Thursday, August 20th on AI contract review playbooks. I know it's become a very hot topic. We will actually teach you how to build your AI playbook for contract redlining, benefits, and tips. It will be presented by Natasha Jeffrey and Stephanie Hildreth. I also want to thank Nate Kostelnik, Lindsay Zubrakis, and the DPM team for producing such an awesome webinar for us. And I would like to thank Docusign for supporting this informative webinar as our parent company. Please subscribe to Contract Nerds email newsletter and follow us on LinkedIn to get contracting tips and learn about upcoming events. Thank you so much for your patience. Stay nerdy and crush those contracts. See you next month.